Aditya, you can see my screen, right?
We can see your screen, yes.
Yeah. So as you know, the telecom bill has been passed in the Lok Sabha, and like Aditya mentioned, it was quite an unexpected move. We were expecting another draft of the telecom bill to be floated, and there was some expectation that this will probably come much later in the next year. But here we are, and we have a new um, telecommunications bill of 2023, which has been passed by one house, and it is now going to be before the Rajya Sabha fairly soon. And as you know, the current situation as it's expected, the bill will go through fairly easily in the Rajya Sabha as well. And it's up to consideration before the Rajya Sabha as we speak. Some of the few key important aspects of the bill. So one key focus here is, look, I'm going to concentrate largely from the perspective of the current regulation, which is the the Telegraph Act of 1885 and the Wireless Telegraphy Act. From that perspective, and we'll also closely look at least some of the important changes from the 2022 version of the bill that we've all seen and provided our comments before. So to look at some of the key definitions in the bill, I think the most important definition being the definition of telecommunication. The definition here is fairly interesting. Before I start on the definition, let me just refresh your memory that in the previous regulation, which is the 1885 Telegraph Act, the frame of the regulation was such that the regulation was on what's known as a layer 3 or a physical infrastructure, which is that if you're operating a telegraph in India, then you needed a license, and that was the exclusive privilege of Government of India. This construct has now changed, and the regulations has moved away from regulating physical infrastructure layer, which is typically layer 1, layer 2 in the typical telecom parlance, to the act of telecommunication itself. And that's what the definition of telecommunication says, that a telecommunication service is something which transmits message by way of wire, radio, optical, or other electromagnetic means. And the term message is also defined in a circular manner, where it says that any message includes text, image, sound, video, data stream, intelligence, or information that is sent through telecommunication. So essentially, what combination of what this regulation intends is that if a message is sent through a telecommunication means and a service is provided, the Act seeks to regulate such activities. So as you know, the frame is very different from the previous act, from a physical layer infrastructure, which is only talking about infrastructure layer and the services on top of it. It is now talking about the act of regulation of the telecommunication itself. And of course, there are other aspects of the act which also talks about regulation of networks and infrastructure and equipment and other aspects relating to it. So the key takeaway here is that it's much more wider in the sense that it could also potentially include any sort of communication which is carried out using telecommunication means. It is not as narrow as it was earlier. The implication could be that even OTT communication could be covered under the broad ambit of the term telecommunication that's defined under the Act or the bill for that matter. Telecommunication does not include OTT, broadcasting services and OTT services, but it appears that it includes OTT communication services, given the wide definition of telecommunication and the message. Telecommunication network is also a defined term, which says that systems of telecommunication equipment or infrastructure used for providing telecommunication services are also governed under the ambit of the bill. Some of the other key important definitions are, one is a definition of telecom equipment. Apart from radio equipment, user equipment, etc., there is also a specific inclusion of software and intelligence in integral to telecom equipment, which is not an entirely different construct altogether when it comes to the definition of telecom equipment which existed in the previous regime. As you know, some of the examples, for instance, the Trusted Telecom Portal also treated software which is integral to telecommunication equipment as a part of this, and also some folks can't see the slides. It is actually full screen. Okay. So and integral to such telecom equipment is also treated as part of being part of TTP portal and the regulations regarding the trusted telecom portal. But having said that, there were several other regulations, for instance, TEC regulations, etc., which only regulated the Telegraph Act aspect of a telecom equipment, which did not specifically include software. Now, the new act is much more wider in its ambit and puts some of these things to rest, that even software which is integral to telecom equipment should be treated as part of telecom equipment under the definition. There's also a new concept of telecommunication identifier, essentially SIM, essentially possibly IP addresses, etc., could be treated as telecom identifiers. Under the bill, there are specific offenses and penalties for certain obligations relating to telecom identifier under the Act as well. There is also this concept of critical telecommunication infrastructure, which could be notified by the government, which is essentially infrastructure which could have a debilitating impact at the national level in the telecom infrastructure layer, is called as the CTI. And there are some specific regulations governing the telecom critical infrastructure as well. Some of the key changes that one needs to look at when you look at a telecom bill. One aspect is that it specifically includes extraterritorial applicability. This is a concept, and the language is also fairly similar to what we have under the Information Technology Act, where if there is any offense committed outside India, and if such act or conduct involves telecommunication services provided in India or an equipment or network in India, then the act will apply even extraterritorially, very similar to the concept that you find under the Information Technology Act. It also moves to an authorization regime as opposed to a service regime. Like I've mentioned some time back before, the exclusive privilege of the government for establishing, maintaining, and working telegraph under Section 4 of Telegraph Act is omitted. But instead, there is a power to grant authorization by the government for providing telecommunication services, the establishment, maintenance, operation, or expansion of telecom networks, and possession of radio equipment. So largely the frame of this, I think what's really changed here is point number one on my slides, which is providing telecom service. Secondly, establishment, maintenance, operation, or expansion. So expansion is a new term here. Earlier, it was largely establishing, maintenance, and operation of telegraph, which was covered earlier, but expansion is now specifically covered. Possession of radio equipment, which is also a feature under the previous Wireless Telegraphy Act, has been retained under the new Telecom Act as well. Moving on to some of the other key changes, there is a specific requirement for biometric identification for availing services, likely to be Aadhaar, likely to be other forms of biometric verification. This is slightly different from the version that's currently in the 2022 bill. It is also different from what's the current practice with respect to unique identification, etc. is currently. KYC, typically there is also an option to do non-Aadhaar based authentication right now. But right now it seems like we are moving to a regime where Aadhaar or other biometric based identification could be used for providing telecom services or availing telecom services. One very important change which has happened, which is probably which puts a policy question at rest, is the assignment of spectrum. As you know, it has been debated for quite some time with large number of entities on one side and very few entities on the other side, whether we should assign spectrum versus whether we should assign spectrum by way of auction or administrative process for SATCOM purposes. That has been put to rest. It is also put to rest some sort of a conundrum that existed in the Indian telecom policy per se. As you know, we have the Supreme Court judgment in the 2G case, Subramaniam Swamy versus Union of India, which said that spectrum should be allotted because by way of an auction because it's a natural resource. But having said that, that's not entirely possible for a large number of use cases. For instance, with respect to backhaul for telecom services, microwave spectrum allotment, use for walkie-talkies and various other allotment, which has continued to be on the base of administrative allotment. So government is walking a slightly contradictory stand when it comes to it for good reasons. Now that's been put to rest, and there is a schedule which has come out which lists out various instances where which spectrum will be administratively allotted, which includes in-flight and maritime connectivity, radio backhaul, space, satellite-based communication, etc., etc. So Moving on to some of the other changes, there is a new concept of regulatory sandbox, where the government has the power to create one or more regulatory sandboxes, and it's basically a live testing environment for products and services with certain relaxations from the provision of the law. And for such purposes as well, spectrum will be allotted administratively by the government, probably similar to the experimental license framework, probably even more, even better than that, because the ambit of this is much wider than wireless telegraph, and the exceptions could be much more with respect to any specific license conditions. Moving on to other changes, the right of way. The current provisions have been largely retained, and with some modifications, which says that a non-discriminatory, non-exclusive basis right of way will be provided, and there is a restoration of compensation to entity in the event of damage to public or private property is a concept which is appearing with respect to the right of way provisions. We have the government has retained public emergency safety interceptions powers largely. They have the right to temporarily process any telecom service, which is something which is again featuring under the previous regime. There is also now a requirement to order disclosure in an intelligible format for the prescribed duration and manner, which means that there should be some amount of decryption that needs to happen, interception and decryption that needs to happen for information to be present in an intelligible manner. There is also power to suspend transmission of messages, power to search and call for information, etc., which is present in the previous regime as well. There are government still retains power with respect to notification of standards and conformity assessment for telecom equipment, identifiers, network, manufacture, import, cybersecurity, encryption, data processing. This is a regime which is not entirely changed. The sort of similar regime continues to apply. There might be some minor changes, which of course we are examining much more closely to see if there is any implication. As you know, government anyway retained the power with respect to security, cybersecurity, encryption, etc. under the previous regime. Sometimes through licenses are not expressly mentioned in the Act itself. Now that's featuring in the statute, which is the Indian Telecom Act. The government has also powers to introduce measures for protection of users. Again, this is something which is coming under the license in the previous regime. So not entirely different. Again, the fact that it's coming into the statute. They also have the measures to take prior requirement consent for specific messages, maintenance of do not disturb registers, etc. It's also slightly bordering on what the TRI is currently handling, and it's interesting to see how this how this sort of two different regimes will work in parallel, because there is one regime which is already put in place by TRI. Will the government do something else? Will they sort of take on some other regulation of specified messages, such as for telemarketing, is something that we need to see. The government also has the power to specify an online mechanism for grievance redressal, which is to be established by service provider. The interesting aspect is that, look, there is already a mechanism which is established by TRI, which is not really effective, which is working in practice. Now the government seems to be suggesting some sort of an ODR mechanism for large amounts of disputes and other aspects. There is also a creation of a new adjudicatory regime, which the government talks about. One is the creation of adjudicating officers. There is a designated appeals committee that's been created right now. And there is the TDSAT also has the power in terms of looking at certain aspects in case there is a matters relating to breach of terms of authorization or suspension. So civil courts in the case of order relating to offences that's provided under Schedule 3. So one aspect here is that there is curtailing of some sort of powers of TDSAT which has happened. TDSAT powers has been curtailed to the extent that certain kind of offences will, anyway, most offences will go to the adjudicating officer. Then there is a designated appeals committee that's formed, and certain cases will go to CDSAT, certain cases will go directly to the civil courts. That's specifically with respect to the offences that's mentioned in Schedule 3. There is also a detailed schedule on penalties for offences and contraventions. There is an increased term of imprisonment for 3 years. There is an increased civil penalty of 5 crores in terms of breach in conditions of authorization or assignment or voluntary undertakings. The offences are cognizable and no longer compoundable, which is another major change with respect to offences that has happened. There are specific penalties that the telecom bill specifically carves out for. One is for breach of terms and conditions of authorization, assignment or other voluntary undertaking, and certain specific contraventions of the telecom bill. Penalties for breach of conditions may be extended up to 5 crore depending upon the severity of the breach, and the penalties for contraventions for unauthorized possession, etc., that could range between 25,000 rupees to 10 lakhs depending on the kind of offenses in question. Some of the noted offenses are: one is actually gaining and attempting to gain unauthorized access to telecom, which is a similar sort of offense that existed in the previous regime as well. But as you know, the imprisonment was merely like a year or so with fines of few hundred rupees. Now that's been changed to 2 crore. And again, it's cognizable and it is something which is not compoundable. Possession of use of telecom equipment, tampering with or non-permissible usage of telecom identifiers, etc. There is some report in the media that this could amount to VPN, use of VPN as well. We don't, at least from a prima facie view, we don't think so. But there it needs to be seen how this tampering with telecom identifiers will be seen and implemented by the government. Similar provisions with respect to unauthorized possession of radio equipment, etc., have been introduced. There's a new penalty for willful possession of a radio equipment using unauthorized telecom identifiers. That's a new class of offense that's been introduced under the Act. Moving on, some of the important aspects here is that, look, it largely saves any sort of previous license which is granted, and under the Telegraph Act or the Wireless Telegraphy Act, all rules and any act which is not inconsistent with the previous regime will continue to apply, which means that the business is as usual when it comes to the date of notification of this bill once it's passed by the Rajya Sabha and gets the president's assent. To quickly talk about the way ahead, it will be presented before the Rajya Sabha soon. It will come in force on a date that the government notifies. There are wide government powers of interception, takeover, etc. There will be further rules issued to provide clarity on some of the aspects of the rule. It's expected that there will be an entirely different licensing regime as well, because somewhere government has been giving the signals that they are talking about unbundling of telecom, and differentiation between an infrastructure, network, and service layer. If that comes into picture, then there will be a different or a complete revamp of the existing licensing regime as well, which is based on the new authorization framework that the government has indicated under the bill. And of course, the confusion with respect to OTT remains. It is to be seen whether the government will actually interpret this provision and put it to use to actually regulate OTT communication services such as VoIP-based messaging and voice-based calling, and whether that will include some of the other existing regime, licenses such as audio text provisioning or online meeting services and online conferencing services. So interesting days to sort of live in this country, and a lot of interesting days ahead for all of us. So I'll pause here. This is very quick, and happy to take any questions. And after this, Aditya, over to you.
Thank you so much, Nikhil, for giving us a brief on the telecommunication bill. I'd like to open the floor to anyone who'd like to ask a question. Please raise your hand, or if you would want to drop your question in the chat box, I can take that up as well. So I think we have, as expected, we have a lot of questions already. Let's go with Amit first and Grace second.
Yeah, first of all, thanks for this nice crisp summary. So a couple of questions. One is on the initial slide, maybe 2 number. Let's talk about the electronic, the telecommunication equipment. So how do we read about it in terms of the impact of that on the OEM side? Second is when they say on the administrative allocation of spectrum and especially on the microwave backhaul. Do you think anything going to happen for this tower infra guys who are looking for rollout of the microwave backhaul for the CSPs, maybe for the neutral host